Welcome back to the Emily Show. This week, we're talking more about Alec Baldwin. I had started to go over his motion to dismiss on the live stream, realized I was going through part of a motion for sanctions against the prosecutor, doubled back to the motion to dismiss, and realized what we really needed to do was a thorough legal breakdown of this motion to dismiss, what it means for Alec Baldwin, go through the new things we learned, like the plea deal he was offered, talk about what Hannah's trial means for him in light of everything he put into this motion. By everything, I mean everything. This motion was over 56 pages long with like 700 pages of exhibits. So we are going to summarize and go through the law and look at the strength of these arguments and whether or not this indictment is likely to get dismissed. And if it does, what comes next? So, all things Rust and Alec Baldwin, we've got a lot to cover today. Let's get into it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to our sponsor, Lomi. I used our Lomi quite a bit as we were getting ready to go away on spring break because I didn't want my house, my refrigerator, or my trash bins to stink when we were going away. And we didn't eat everything in the fridge that would go bad during the time that we were gone. So it all went into the Lomi and then went directly into my garden outside. So you can take your food waste and with a push of a button, easily turn it into dirt that you can use for your plants, lawn, or garden, instead of putting it in your trash cans and then sending it to a landfill. So whether you're looking to make a positive environmental impact or just want a more beautiful garden or just want your trash cans to stink less, the Lomi has got you covered. Head to lomi.com/lawnerd and use promo code LAWNERD to get $50 off your Lomi. That's $50 off your Lomi at lomi.com/lawnerd and use code LAWNERD. Thank you again, Lomi, for sponsoring this episode of The Emily Show. Let's get back to it. So an overview of what Alec Baldwin is arguing in this motion to dismiss the indictment is that the prosecution gave the grand jury improper jury instructions and that the court can evaluate whether or not the prosecution improperly withheld exculpatory evidence and that the prosecution acted in bad faith, which gets you in the door to look at whether or not the prosecution withheld necessary exculpatory evidence. So even within this motion, there are two different standards that the court needs to review. Often the court can't really intercede into what grand juries do. Even though there are over 700 pages of exhibits here, there are still some things that aren't included, including the grand jury transcript. And though those parts of the motion aren't sealed, which actually surprised me, because often when they're quoting directly from what the grand jury is doing, that is all kept under seal. That was not done here, but it's hard to evaluate the full context of how the defense is arguing what the prosecution said and did without evaluating that full transcript. So we are taking that when it comes to what was said in the grand jury at face value based on what the defense said. Yes, the defense sought and received permission from the court to exceed the statutory page limits because this is longer than you're generally allowed to go. And the prosecution sought and received extended time to answer. So their response to all of this isn't due until April 5th, 2024. For a little bit of background here, the first time Baldwin was charged, it was the prior special prosecutor. So a large amount of this motion is going over the beef that Baldwin's team has with the prosecutors because they do need to cross that threshold of whether or not there was bad faith on the part of the prosecutor before they can evaluate whether or not exculpatory evidence was withheld from the grand jury. Now, to argue that the jury instructions to the grand jury were improper, they don't need to cross that bad faith threshold. So I think that argument is a little easier. And as I always say, jury instructions are one of those things that can get a case overturned pretty quickly if they are done wrong. It needs to be done according to the law. It needs to be done precisely. Giving the wrong jury instruction, withholding jury instructions that are necessary, even the judge misreading the jury instruction and not correcting it can all be grounds for appeal. It's also what we saw Koberger arguing on his motion to dismiss the indictment, though his arguments were different than these and were based in the fact that the entire standard for grand jury proceedings was wrong, and that didn't get very far. And we've seen that recently, not only denied by the judge twice, but denied by the Idaho Supreme Court, where they're like, we're not even taking this up. The standard is probable cause, and that's what the grand jury did here too. But Baldwin was originally indicted by the prior special prosecutor who was discussed in this motion. Then the new special prosecutor, Carrie Morrissey, came into this case. She's the one you saw at trial prosecuting Hannah Gutierrez. She is still the prosecutor indicting and prosecuting Baldwin. She originally dismissed the case against Baldwin without prejudice and then later refiled it by indictment. What's interesting is that we learn from Baldwin through these motions, and I'll probably go over it again, is that before she sought an indictment in this second prosecution of Baldwin, she offered him the same plea deal that Dave Hall's got. And if you watched my coverage of Hannah Gutierrez's trial or followed my coverage of the Rust case, you'll know how I feel about the very lenient plea deal that Dave Hall's received. Alec Baldwin was also given the opportunity to plead to that misdemeanor negligent handling of a firearm for 6 months of unsupervised probation. Now, the prosecution had given him a time span to respond to that plea deal offer, and Baldwin's team says that the prosecution revoked that offer 10 days before the deadline was up and decided to go forward on an indictment. And we actually heard the prosecutor in the closing arguments of Gutierrez's trial saying, I'm the one who's prosecuting Alec Baldwin. I'm the one who indicted him. What no one's ever really made clear is that he was also offered a misdemeanor plea deal. Whether he would have ever taken that or not is not something the defense discloses. But they do make much of the fact that the prosecutor yeeted that plea offer 10 days before the deadline that they had extended to Alec Baldwin, which is just not a great way to go forward with it. But a lot of things done in this prosecution have been odd for me, just really odd for me. So prosecutors then took Baldwin back to a grand jury, and the grand jury indicted him on January 19th, 2024, and that's where we're here. But prior to that grand jury indictment, Baldwin was given a target letter, and then there was litigation over what would be presented at the grand jury and how, and what jury instructions might be used at the grand jury and why. It's a very interesting procedure in New Mexico, the way that they give someone a target letter, and the defendant has more rights at this grand jury or more rights to give information to a grand jury in New Mexico than I've seen in any other jurisdiction or in federal matters. In federal matters, oftentimes someone is indicted and then the indictment's unsealed and they're searched or arrested. Don't worry. As I've been prepping for this podcast today, all of the news has been breaking about P. Diddy. We will cover it, I promise, but not in this podcast episode. So you will see someone get indicted by a grand jury. That is kept secret until the indictment is unsealed after they are arrested. Sometimes if people are being investigated and there are subpoenas or search warrants, they will get a target notice that they are the subject of an investigation, but often not told that they are going to be indicted and not given the opportunity to ask for information to be presented to the grand jury. It's a very interesting process in New Mexico, and again, different than I've seen in any jurisdiction. It really is one of the things I enjoy the most about this podcast and about doing the live streams on YouTube is that we get to learn so much about the different laws all across the United States and look at really the intricacies of those laws in different jurisdictions and how different jurisdictions do things, because they can vary wildly. I mean, hell, last week we learned that in Utah, not only does the court offer a quote unquote thinking errors class, but also the actual legal name of the charge for making methamphetamine or having a meth lab is clandestine chemistry. And I don't think I'm ever going to get over that because it's just, I think, the most brilliant naming of a charge that I've ever seen. And that was delightful to discover going through all of the new documents in the Corey Richins case. Clandestine chemistry, I will stand by, should be a band. If it's not already, I might make band shirts, even though I'm not in a band, because it's just so good. But back to Baldwin, no clandestine chemistry charges here. But he did get a target letter. He did have an opportunity to respond. And that's where a lot of the litigation before the indictment happened. We're going to go through what the court's rulings were first. Then we're going to look at the law together. Then we're going to go through what Baldwin's attorneys are arguing the state did wrong here. And throughout that, we're going to talk about what we learned from Hannah's trial, because a lot of not just Hannah's trial, but the interviews from the witnesses that ultimately testified in Hannah's trial were brought up in the motions here. As you can imagine, it's a lot of the same witnesses that testified at Hannah's trial are going to be the witnesses that we will see when Baldwin ultimately goes to trial. It's funny because Baldwin's lawyers actually linked some of the days of Hannah's trial into their motion when they were talking about witnesses testifying differently at trial than they had at grand jury. And if that is accurate, then that will definitely come up when this goes to trial. But it's really hard to evaluate for me without those transcripts from the grand jury, which are secret and should be sealed, even though we didn't see a sealing motion. So it's hard to evaluate if they are sealed. I can only assume that they are because they were not included in the public filings of these motions, which I'm not arguing is inappropriate. It is appropriate. It's just difficult then to evaluate the whole thing. So I hope that going through the court's ruling and then going through what the statute actually says gives us a really good, we dive into the arguments of the defense. And when we start parsing through what is a lot of slinging mud at the prosecution and rehashing old grievances with the prosecution, and what is actually the legal substance of the motion, because so much of it is just tea and mudslinging. Like so much of it. I think they really could have stayed within the page limits on their legal arguments and merits if they didn't take so much time rehashing the entirety of the litigation, though I understand that Baldwin's attorneys are arguing that there is bad faith on the part of the prosecutor here. And so they're going to start from the very beginning, because it is a very good place to start, and rehash every grievance that they have with this entire prosecution from the jump. Thank you to our sponsor, Shopify. Not only are they the e-commerce solution behind the Law Nerd Shop, but they are an incredible sponsor of the podcast. Shopify is the global e-commerce platform that helps you sell at every stage of your business, from launch your shop online to the first real life store, all the way to did we just hit 1 million orders. Shopify is there to help you grow. So no matter what you're selling, whether it is tumblers in the Law Nerd Shop, hoodies and sweatshirts, or art, they've got you covered. And Shopify helps you turn borrowers into buyers. It's shown that they are the internet's best converting checkout, 36% better on average than other leading e-commerce platforms. It's not a wonder that Shopify powers 10% of all e-commerce stores, from the Law Nerd Shop to Rothy's and Brooklinen to your favorite nail polish. Plus, Shopify's award-winning help is there to support you at every step of your business. It's no wonder that businesses that grow with Shopify. If you have been thinking about selling online or in person, Shopify has a solution for you. And you can sign up for a $1 per month trial period at shopify.com/lawnerd, all lowercase. Go to shopify.com/lawnerd now to grow your business no matter what stage you're in. And you're going to start hearing this sound soon. Let's get back to today's episode. So the first thing we're going to look at is the court's order regarding the state's motion to preclude requested testimony and evidence before the grand jury. So this is the court ruling on the prosecution's attempt to keep out evidence that the defense was asking to be presented to the grand jury. And this is from January 11th, 2024. So this was coming right down to the wire before that grand jury hearing happened. Order on the state's expedited motion to preclude Target's requested testimony and evidence before the grand jury. Remember, here Baldwin is going to be referred to as the target. He's not been indicted yet. He's not a defendant. He's the target of the grand jury's inquiry or decision. So that's why he is called the target. The court's procedural summary is as such. And I went through this because it is so much litigation and the court distills it so well. One of the things you learn in law school is to not recreate the wheel where you don't have to. And this already took a tremendous amount of work to summarize. So I'm definitely not making work for myself here. The court says, quote, on November 15th, 2023, the state filed its expedited motion in response to an alert notice entitled, quote, Grand Jury Evidence Notice to District Attorney, dated November 14th, 2023, and provided to the state by Target pursuant to New Mexico Rule 5-302.2c. The court initially held a remote hearing to consider oral argument on the expedited motion on November 15th. However, given the length and breadth of the expedited motion, the court rescheduled this hearing to January 11th, 2024. On January 11th, 2024, the court held a remote hearing to verbally announce its decision. Present at the hearing were the special prosecutors and the defense team for Baldwin. The court exercises its discretion to rule on the filed pleadings without considering oral argument. What that means is the court was like, based on everything you've written, I am making my findings. I am not hearing these attorneys go on and on and on again. I empathize with the court in this. The motions in this were extensive. All of them were attached. It was quite a lot of back and forth. And so the court has the discretion to just rule on the motions and not let everybody verbally rehash what they had written. Analysis. The court overrules the bulk of the state's objections to the target's evidence. Quote, when serving as an aide to the grand jury, a prosecuting attorney must facilitate the grand jury's inquiry into any lawful, relevant, and competent evidence not initially presented by the state and cannot unilaterally withhold evidence or witnesses requested by the grand jury. That's coming from the case Herrera versus Sanchez. And the court said, see also State v. Cruz, quote, in dealing with the grand jury, the prosecutor's duty is to protect both the public's interest and the rights of the accused. Remember, at a grand jury, the defense is not physically there. The defendant, unless they testify, which they have a right to do in New Mexico, is not physically there. The prosecution is obligated to present both sides. If there is clear exculpatory evidence known to the prosecution, they must present that to the grand jury. So that's why you're hearing this language that the prosecution has a duty to protect everyone's rights in this. The court then goes on to cite the New Mexico statute, section 31-6-11, subsection B, quote, the target or his counsel may alert the grand jury to the existence of evidence that would disprove or reduce an accusation or that would make an indictment unjustified by notifying the prosecuting attorney who is assisting the grand jury in writing regarding the existence of that evidence. So they must submit it to the prosecution, they must submit it in writing, and they must point to evidence that would either disprove or reduce an accusation. And that might mean taking a charge from a greater charge to a lesser charge, etc. The language that's important of that is just really notifying the attorney in writing. But the language from the other section that is important is that the prosecution must facilitate the grand jury's inquiry. It doesn't say how they must facilitate the grand jury's inquiry. We will come back to that. It goes on to say, quote, if the target timely submits a grand jury alert notice to the prosecutor is obligated to alert the grand jury to any target offered evidence that is lawful, competent, and relevant, and that would disprove or reduce an accusation or make an indictment unjustified. It goes on to say, notably, New Mexico's grand jury statutes require only that the prosecuting attorney alert the grand jury to the existence of target offered evidence and do not require the prosecutor to actually present such evidence. And it cites case law for that. Very relevant to the defense's argument. What the defense is arguing in their motion to dismiss is that the prosecution didn't present the evidence they wanted, and that the prosecution merely read the target letter from Baldwin's attorneys to the grand jury. And that's exactly what it seems that they did, that they read the target letter into evidence and then gave the grand jury time to consider it and ask if they wanted any of those witnesses or not. On the target letter, it listed all of the witnesses' phone numbers, email addresses, contact information. It was clear that those witnesses were available to contact, I think, from the target letter and the way the target letter was written. But the law cited by the court says that the prosecution doesn't have to present that evidence. It only has to alert the grand jury that it exists and that the target offered it. And reading the target letter seems to me to cover that caveat of law in New Mexico. The court goes on to cite another case, Jones, saying, quote, thus, in light of past practice, it would be unreasonable to conclude that the legislature decided to explicitly give the target the right to alert the grand jury to the existence of exculpatory evidence while nevertheless allowing the prosecutor to reject such offers without a check, particularly since the 2003 amendments to the same code section also eliminated the prosecutor's duty to present evidence that directly negates guilt. So there are legislative updates that the case law is considering in how the prosecution has to do this. Again, they have to alert the grand jury, but alerting and presenting evidence are two different things. It goes on to say, once alerted to target offered evidence, the grand jury remains free to decide not to hear the evidence or to hear the evidence and weigh it as it sees fit. And that is a different case, quoting the Jones case. The defense ignores all of that from the court's ruling in their motion. The defense continues to argue throughout their motion to dismiss that the grand jury is obligated to go through everything in their target notice, where the case law that the court is citing indicates clearly that the jury can choose to hear it or to not hear it. Like, do you, grand jury. It goes on to say, quote, here, invoking Rule 5-302.2, subsection C, the target provided the state with a grand jury evidence notice to the DA on November 14th, 2023. In turn, via this motion, the state objects to nearly all the evidence about which the target seeks to alert the grand jury. Specifically, the state argues that the target is permitted to propose only that testimony and evidence that is directly exculpatory. Circumstantial exculpatory evidence is not permitted. The state is required to present to the grand jury only exculpatory evidence that directly negates the defendant's guilt. And the court then quotes where the DA says that in their motion. It goes on to say that in support thereof, the state cites to cases that precede the paradigm-shifting decision of Jones v. Murdoch, 2009, and the subsequent expounding decision of Herrera v. Sanchez. Ultimately, the court disagrees with the state's analysis. What is critical that the court said is that the law of the land shifted substantially, a paradigm-shifting decision of Jones, meaning in their motion, the prosecution was citing not just old law, but old and overturned law, which is a giant oof. And since the former special prosecutor ran into the problem of not only charging Baldwin with an enhancement that couldn't legally be charged, but then touting it to the media and saying, there's this 5-year mandatory minimum sentence because of the gun charge, a gun charge that couldn't legally be charged. We've had this happen again and again in this case. Look, some people think being a prosecutor is easy. It's not. But there's a lot of programs that let you key cite cases and like alert you that they've been overturned. So not knowing that a case has been overturned and overturned in 2009 is kind of a big one for me. And I will say the defense makes much of it and continues to roll around in delight with the fact that the prosecution relied on overturned law, just delighted in it. The court goes on to say, rather, the court's analysis is guided by the analytical framework developed in Jones and Herrera. We love a framework. As explained in Herrera, quote, the grand jury judge must determine whether the target offered evidence is, quote, lawful, competent, and relevant, and whether the evidence disproves or reduces a charge or accusation or makes an indictment unjustified, which is exactly what the code says. Like, stick to the code. The court goes on to say, hence, the target offered evidence need not be directly exculpatory to compel the state to alert the jury to its existence. Further, quote, because the legislature intended to give the grand jury access to more evidence, not less, the prosecution carries the burden of persuading the grand jury judge that the grand jury should not be alerted to target offered evidence. Regarding the target proposed witnesses and tangible evidence, the court finds and concludes and orders as follow. As to the following witnesses: Joel Souza, Dave Halls, Sarah Zachary, Ryan Smith, Detective Alexandria Hancock, Detective Joel Cano, and Robert Schilling. The ruling is as follows. The state fails to persuade the court that the potential testimony is not lawful, competent, or relevant. Further, the state fails to persuade the court that the potential testimony may not disprove or reduce a charge or accusation, or may not make an indictment unjustified. The state shall alert the grand jury to the existence of these witnesses and their potential testimony via the target's grand jury evidence alert letter. Now we get into documents. Recording of the 911 call, the prop truck warrant, the church search warrant, PDQ arm and prop search warrant, New Mexico OSHA report, excerpts from the Santa Fe Sheriff's Office reports regarding Joel Souza, Hannah Gutierrez Reed, Sarah Zachary, Dave Halls, Reed Russell, Jensen Eccles, Ross Adiago, Sarah Zachary's cell phone report, Seth Kinney's cell phone report, text messages between Sarah Zachary and Seth Kinney, text messages between Hannah Gutierrez Reed and Seth Kinney, a crew letter, 2 video clips from the Russ set, and Dave Halls's proffer transcript, meaning the transcript when Dave Halls sat down with the prosecution and went through what he knew, what he saw on set, and kind of locked in what testimony he would offer when he was called to truthfully testify when he took a plea deal. If you're interested in going through that proffer transcript, let me know. Maybe we can do that another day. We're definitely not going to have time to do it in this episode. The ruling as to all of the things I just listed off by the court was that the state fails to persuade the court that the proposed evidence is not lawful, competent, or relevant, fails to persuade the court that the proposed evidence may not disprove or reduce the charge or accusation, or may not make an indictment unjustified, and the court shall alert the grand jury to the existence of this evidence and the corresponding non-argumentative description via the target's grand jury evidence letter. That will come up again in a minute. The non-argumentative target letter. The court goes on to talk about the industry-wide labor management safety bulletin, document number 11, and a different video clip from Rust. And in that, the court says that the state will present these materials to the grand jury because the state had already agreed to present them. So there are multiple things that the state had agreed to, and the court's just reiterating that the state agreed to show those. Then we get to excerpts from an office report regarding Ataya Luce, and the court said for that particular excerpt from the sheriffs to that particular witness that the court grants the state's motion to exclude this information from the grand jury target letter. Based upon the proffers and proposed evidence, it appears not relevant and does not appear to disprove or reduce the charge or accusation or make an indictment unjustified. It goes on to say that the court refrains from addressing the state's objections to the target's proposed questions. So in the target letter from Baldwin, they proposed questions to all these different witnesses. As to that, the court says the state's expedited motion comprehensively analyzes the target's proposed questions for the target's potential witnesses. However, as explained by the New Mexico Supreme Court in Jones, The New Mexico Supreme Court finds it imprudent to fashion a pre-indictment mechanism to ensure that the prosecutor questions the witnesses in a manner proposed by the target or otherwise elicits the evidence in a way that the target intended. To begin with, the grand jury very well might decline to hear the target offered evidence upon learning of its existence. And if a grand jury does ask the prosecutor to call the target offered witness, to require the grand jury judge to formulate the script by which the prosecutor must question the witness would be highly impractical and most likely ineffective. It goes on to say, rather, if the prosecution intentionally questions the witness in a manner intended to keep the witness from providing the grand jury with the information that the target wanted before the grand jury, then the only practical recourse for the target must come post-indictment, after the target has an opportunity to review the transcript of the grand jury proceedings to evaluate the fairness of the prosecutor's actions. So the case law very specifically said, we're not going to tell the prosecutor how to do their jobs. Prosecutors have pretty wide latitude when it comes to grand juries, but the defense can remedy that after the indictment by reviewing the grand jury proceedings and then bringing it to the court's attention. The court rules by declining to prescribe the exact manner of questioning by the state for any target alerted witnesses, but cautions the state on the target's potential remedy identified if the state's questioning runs afoul of the standards described in Jones. So the court here is pointing the prosecution to the proper standing law and saying, that is what you need to follow. That is the law of the land. And it lays forth how you are to question witnesses if the grand jury wants to hear from them. Spoilers. The grand jury didn't want to hear from them. Yep, the grand jury didn't ask for a single one of the defense witnesses. Not a one. Didn't want to hear from it at all. The court instructs the target to rewrite its grand jury evidence alert letter within the parameters set forth in New Mexico Rule 5-302.2, stating when a target elects to submit an evidence alert letter to the grand jury, the target's submission shall consist of factual and non-argumentative description of the nature of any tangible evidence and the potential testimony of any witnesses, along with the names and contact information of any witnesses necessary to provide evidence. Here, the court finds that the target's proposed jury evidence letter contains argument in several instances. And then the court lists out the Black's Law Dictionary definition of argument, being a statement that attempts to persuade by setting forth reasons why something is true or untrue, right or wrong, better or worse. The court then instructs the target to modify its grand jury evidence letter to remove the struck language as appearing attached. And I will show you the attached just briefly. The court goes through the Baldwin letter that was their proposed letter to go to the grand jury and strikes out portions of it so that it's very clear what will be presented to the grand jury. The court goes on to say that they decline to instruct the state on the logistics of securing the availability of target alerted witnesses and tangible evidence, stating, quote, once alerted to target offered evidence, the grand jury remains free to decide not to hear the evidence or to hear the evidence and weigh it as it sees fit. Free to decide being the key and operative words here, no matter how much Baldwin's defense attorneys do not like that is what the case law says. Accordingly, the court instructs the state to make readily available any proposed tangible evidence and potential witnesses to avoid scheduling disruptions if the grand jury wishes to hear the evidence once alerted. However, the court declines to provide additional instruction to the state on securing witness availability, stating, quote, when serving as an aide to the grand jury, the prosecuting attorney must facilitate the grand jury's inquiry into any lawful, relevant, and competent evidence not initially presented by the state and cannot unilaterally withhold evidence or witnesses requested by the grand jury. Conclusion, it is therefore ordered. Conclusion, do what I say. That's the conclusion here. So the court took everything that the attorneys threw at it and said, look, we are not limiting the witnesses except for one, and we are limiting the amount that Baldwin's attorneys can argue in this target letter. And then as an exhibit, the evidence alert letter is attached with the court's strike-throughs of quite a lot of what the argument is. I went through and redacted the witness contact information. But as an example, with regard to Joel Souza, who we saw testify at Hannah Gutierrez's trial, potential testimony, the defense wrote, Mr. Souza is the director of Rust. He was primarily responsible for all creative aspects of the film and relied on the entire cast and crew to bring his creative vision to life. He was present in the church during the rehearsal scene and was struck by the fatal bullet after it passed through Helena Hutchins. He suffered non-life-threatening injuries. The court went through that and struck out and relied on the entire cast and crew to bring his creative vision to life, struck out fatal, and struck out non-life-threatening for the injuries. So it really went line by line on each of the witness descriptions and for the potential document descriptions, and really eviscerated a lot of what the defense had intended to be in here. Later in the letter, they also talk more about the Santa Fe Sheriff's Office report, which goes through their interview of Joel Souza. And again, the defense says, quote, the report indicates that Souza, who was hit by the bullet that fired the day of the incident, recalled Hannah Gutierrez Reed standing over him apologizing. He identified her as the person on set responsible for firearms and that guns are to be checked by the armorer, Gutierrez Reed, and the first assistant director, Halls. The court had that whole last sentence struck. The quote, he identified her as the person on set responsible for firearms and the guns are to be checked by the armorer, Gutierrez Reed, and the first assistant director, Halls. And so the court went through and made sure that any argument or shifting of blame or indication of who was responsible was taken out of this target letter. When it comes to the report regarding Jensen Ackles, it said, the report indicates that Ackles explained that it is not the job of an actor to check their own firearms. Ackles also reported that he had not seen Baldwin handle firearms in a reckless manner on set, and that at the time of the incident, he had heard Helena Hutchins tell Mr. Baldwin to, quote, show her the action just before the fatal shot fired. Most of that was struck out by the court and left, essentially, the report indicates that Ackles reported he heard Helena Hutchins tell Baldwin to, quote, show her the action just before the shot fired. So you can see how much the court really took out of this target letter. Next, we are going to look at the court's ruling with regard to the jury instructions. Thank you to today's sponsor, Fast Growing Trees. Did you know Fast Growing Trees is the biggest online nursery in the US with more than 10,000 different kinds of plants and over 2 million happy customers in the US? You can grow lemon, avocado, olive, or fig trees inside your home on top of a wide variety of house plants, and you can even search those by pet-friendly houseplants, which I love. Fast Growing Trees makes it easy to order online, and your plants are shipped directly to your door in 1 to 2 days. Along with their 30-day Alive and Thrive guarantee, they offer free plant consultations forever, which means if you forget what type of plant you have or forget how you need to care for it like I am wont to do, you can reach out to them and they will help with what's going on with your plants. I love how easy they make it to find the type of plant that you're looking for, whether it's more shade for your yard, something that's pet friendly for inside, or you want to grow your own food, or your landscape design, which is what we're going to be doing with a bit of a redecoration of the front yard. Because, now the bird feeders need a whole landscape built around them. Right now, they have the best deals online, up to half off select plants, and listeners of our show get an additional 15% off when using code LAWNERD at checkout. That's an additional 15% off at fastgrowingtrees.com using code LAWNERD at checkout. And don't forget to tell them you came from The Emily Show. Let's get back to today's episode. This is the order granting in part and denying in part the state's motion to exclude Target's requested elements instruction to the grand jury. The procedural summary is much the same, but it goes through talking about the jury instructions and not the witnesses. So we're not going to go back through the procedural summary and just the court's analysis. The court says the state's motion makes 3 primary arguments. First, the state asserts that the target does not have the right at this stage in the process to determine what instructions and definitions are provided to the grand jury. Second, the state contests the target's requested addition to UG 14-2321, UJI, Uniform Jury Instructions. Sometimes they call them model uniform jury instructions, and then they're MUJIs. So if those are MUJIs, then these are UGs, and I'm going with it. Uniform jury instructions is too long to say, and UJI sounds like something you get treated at the doctor. So UG it is. And the New Mexico model rules, as well as UG 14-133, to reflect that the, quote, criminal negligence standard requires the prosecution to show that Mr. Baldwin had subjective knowledge of an actual risk that the firearm placed in his hand had been loaded with live ammunition. Third, the state disagrees with, or at least does not address, approximate cause instruction requested by the target. The court addresses these issues below. It's interesting because in the case law regarding grand jury instructions, there are other instances where the court did not require a proximate cause instruction, and that was not error in a way that would overturn a grand jury indictment. So other case laws found that depending on the case, approximate cause instruction is not necessary. And though we did go over this in the Gutierrez Reed case, proximate cause is showing that the action done by the person is the primary and legal cause of a particular harm. When jury instructions were done in Hannah's trial, when we heard closing arguments, they argued proximate cause, and they also talked about any intervening cause or subsequent intervening cause. And the defense was arguing not just the medical care could have been an intervening cause, but Baldwin was an intervening cause. So was Hannah really the primary cause of the harm, in this case, the death of Helena Hutchins, or was it Baldwin? But there can be multiple factors that cause a harm, and it should be remembered that just because something is the first act or the last act, it doesn't change whether or not it is a proximate cause in this action. So the court is addressing whether or not a proximate cause instruction. The defense wants to argue that Hannah loading the gun with a live round is the proximate cause of Helena Hutchins' death. And they're going to argue probably that she was tried for this. I wonder how much we'll see that in the run-up to Baldwin's trial, and how much his defense attorneys will try to get into the fact that Hannah Gutierrez was prosecuted and convicted for the death of Helena Hutchins. She's the proximate cause. Without her loading a bullet into the gun, none of this happens. Guns are used on movie sets all the time, and this doesn't happen. Therefore, Hannah and her action or negligent inaction are the proximate cause of the death of Helena Hutchins, not Baldwin's handling of the weapon. So now that we've sidetracked to proximate cause, let's get back to what the court was saying. Regarding the state's first argument, the court disagrees with the state, saying, quote, if the target submits written notice to the prosecuting attorney of exculpatory evidence or a relevant defense, the prosecuting attorney shall means must, shall alert the grand jury to the existence of the evidence. Alert. Again, not present, alert. The court goes on to quote that the prosecuting attorney who is assisting the grand jury shall provide the grand jury with instructions setting forth the elements of each offense being investigated and the definitions of any defenses raised by the evidence. It's interesting because the defense argues that there were instructions that should have been given, but the instructions on the defenses must be raised by the evidence. So if the grand jury is notified of the potentiality of evidence and declines to hear that evidence, then the issue isn't really raised by the evidence because the grand jury chose not to hear from those witnesses. So I don't think an instruction needs to be given if the grand jury chooses not to hear from the potential exculpatory witnesses. The court goes on to say, thus, to the extent that a target notices the prosecution to a relevant defense and a jury instruction relates to the notice defense, the court concludes that the target may raise objections to any proposed jury instructions that bear on the noticed defenses. So the defense can argue it. The prosecution was saying they couldn't. The court goes on to say the court denies the motion to the extent it argues that the target may not take issue with the instructions to the grand jury that bear on relevant defenses. It goes on to say regarding the state's second argument, the court agrees with the state. When a uniform jury instruction exists, that instruction must be used without substantive modification. Keep that in mind. It's going to come up a lot. The defense is arguing that the state argued to the court in these motions to not modify the uniform jury instructions, UGs, and then went ahead and modified it when they read them to the grand jury, and therefore the state gave instructions that were modified from the uniform jury instructions, and therefore the grand jury was instructed wrong, and therefore the indictment must be tossed. The court says in this ruling, quote, in addition, fundamental error exists when the instruction given, quote, differs materially from the uniform jury instruction, omits essential elements, or is so confusing and incomprehensible that a court cannot be certain that the jury found the essential elements under the facts of the case. So, I think the strongest argument on Baldwin's motion to dismiss comes from this citation from the court. Did the way the prosecution present the jury instruction differ materially from the uniform jury instruction? I think that's their strongest argument, and I think that's the main point. Whether or not the exculpatory evidence was presented, I think reading the target letter meets the law as it's said here. But how the court is going to interpret differs materially will be interesting to see, because I think there might be an argument there, and we'll get to it. The court goes on to say here, the target proposes to supplement UG 14-230, 1 and 133, such that, quote, the state must describe the danger or risk of which the target supposedly should have known vis-a-vis element numbers 2 and 3 of the uniform jury instruction. Specifically, Baldwin contends that, quote, the grand jurors should first be instructed that the criminal negligence standard requires the state to prove that Baldwin had subjective knowledge of an actual risk or danger to Hutchinson's life, and that the grand jury should next be instructed that in order to indict Baldwin, the state must prove that Baldwin was aware of the risk at issue, the risk that the gun was likely loaded with live ammunition, and that he willfully disregarded this risk by following Hutchinson's direction to point the gun towards the camera. The court goes on to say the requested instructions materially differ from the UGs. Therefore, the court grants the state's requested exclusion of the target proffered criminal negligence standard instructions. The court moves on to the state's third argument, saying that the state conceded in its reply that it will present UG 14-251 for the grand jury's consideration regarding proximate cause. The court says, however, the target requested that the state provide both 14-251 and 14-252 to the grand jury. The state's amended reply is silent on the position. Given the silence, the court cautions the state that it must provide 14-525 if the evidence supports its provision to the grand jury. And then it says, see the use notes of the UGs, quote, for use in conjunction with UG 14-251. When there is evidence of negligence by another person, this instruction may be modified and used as appropriate in non-homicide cases. Quote, furthermore, we have determined that when there is evidence to support a finding of every element of a defense, an instruction on that defense is required, and our grand jury statutes require the prosecuting attorney to act in a fair and impartial manner at all times during the grand jury proceedings, including when instructing the grand jury on the applicable law. By adhering to the instructions modeled in the uniform jury instructions promulgated by the New Mexico Supreme Court, the prosecuting attorney can avoid improper statements and fulfill the dual obligations of protecting not only the public interest, but also the rights of the accused. Conclusion, the state's motion is granted in part and denied in part. So it's going to come down to, I think, whether the court feels that there is evidence that requires the state to go through both of those 14-252 and 14-251 jury instructions, whether they failed to do that, and that gets into the negligence of another person. I can't imagine this grand jury went forward without much conversation about the role of Hannah Gutierrez Reed, or at least some conversation of it, because there was a loaded bullet in the weapon. Baldwin didn't load the weapon. There would have had to be discussion how a bullet ended up in the weapon. And now that we've gone through what the court ruled that the prosecutor needed to do at the grand jury, let's take a moment to take a look at what the statute says the prosecutor must do at the grand jury. And this is coming from the New Mexico statute 31-6-11, titled Evidence Before the Grand Jury. Evidence before the grand jury upon which it may find an indictment is that which is lawful, competent, and relevant, including the oral testimony of witnesses under oath and any documentary or other physical evidence exhibited to the jurors. The rules of evidence shall not apply to a grand jury proceeding. The sufficiency of the evidence upon which an indictment is returned shall not be subject to review, absent a showing of bad faith on the part of the prosecuting attorney assisting the grand jury. That is why the defense spends so much of its motion really bitching about the prosecution. The defense is trying to overcome a very, very high bar to get to showing prosecutorial bad faith, because the court cannot review the evidence without that showing. They can review the jury instructions without this showing, though. Subsection B says it is the duty of the grand jury to weigh all the evidence submitted to it, and when it has reason to believe that other lawful, competent, and relevant evidence is available that would disprove or reduce a charge or accusation, or that would make an indictment unjustified, then it shall order that evidence produced. And this is where we see a discrepancy between the languaging of the code that says shall, and in the law, shall generally means must, and the court's previous ruling, which cites all the case law, that says the grand jury can. It may ask for that, but it's not obligated to. The code goes on to say at least 24 hours before the grand jury proceedings begin, the target or his counsel may alert the grand jury to the existence of evidence that would disprove or reduce the accusation, or that would make an indictment unjustified, by notifying the prosecuting attorney who is assisting the grand jury in writing regarding the existence of that evidence. So 24 hours before the grand jury is when the defense has to turn this over. It then goes on to say the district attorney shall use reasonable diligence to notify a person in writing that the person is the target of a grand jury investigation, then goes through the procedures to do that. And remember, I said in that subsection B that it said that the grand jury shall request that evidence, but the case law clearly indicates, and even the notes from the statute indicate, that without showing prosecutorial bad faith, the court can't evaluate whether or not the grand jury did that after the indictment happens. And the notes under the statute make it very clear that even when it comes to exculpatory evidence, without that bad faith finding, the court cannot evaluate whether or not that evidence should have been presented to the grand jury or not. But the court is also very clear that it could be a denial of the defendant's due process when the prosecutor withholds exculpatory evidence from the jury. I think that reading in the target letter is not withholding that exculpatory evidence, but the defense has a high bar to get to that determination of bad faith before the court can evaluate that question at all. If the court finds that there was no bad faith here, then this question is going to be completely moot. And then it moves on to the question of whether or not the state materially altered the jury instruction. So let's get into the defense's motion in their own words. Because now that we've looked at the law and we've looked at what the court had to say, we know the standard that the defense needs to prove. We know that for the error that they're looking for on the jury instructions, they don't have to show prosecutorial bad faith, but to get to the exculpatory evidence and the witnesses, and that they need to show bad faith. And they don't hesitate at the beginning of their motion, saying the prosecutors obtained the indictment against Alec Baldwin by circumventing fundamental protections over and over and over again. The criminal case against Baldwin started in January 2023 when the Wall Street Journal called Baldwin's attorneys to inform them for the first time that Alec Baldwin was being prosecuted for involuntary manslaughter. Immediately after, the state announced the decision publicly and went on a viral press tour to tell the world that Baldwin was guilty and faced a mandatory minimum 5-year prison sentence. It goes on to say the state's unethical disparagement of Alec Baldwin was a sign of things to come. And because at some point they do argue that the state dragged Alec Baldwin. We'll get to the dragging later. The defense goes on to say, in talking about the ruling that we just reviewed, that the court's ruling came just days before the grand jury presentation was set to start, which, given the grand jury schedule, left only 2 days for the state to present the entire case before the grand jury's term expired. And the grand juries in New Mexico are seated by kind of lumps of time, a lump term. And when the term expires, that set of jurors are done. What was so interesting, as I sidebar, what was so interesting is that the defense argues that the state had been warned by the court about not disclosing information because in the previous grand jury term, grand jurors had actually gone to the clerk's office and said, hey, we hear that there's a grand jury coming up in the Baldwin case. I want in, essentially. And that the court had ordered that the prosecution not talk to the media about the date of the grand jury. Grand jury proceedings are supposed to be very secretive, and the date of the grand jury was out there, and reporters told Baldwin's attorney that all came from the prosecutors. And this is all being dragged out again in these motions to show that the prosecution, from the defense's perspective, is acting in bad faith. So in the motion, they are saying that Baldwin warned the state in writing that it would not have enough time to present the evidence from his alert letter before the term ended, and that he asked the state to adjourn the grand jury date to ensure his evidence could be presented. Look, he doesn't have a right to tell the prosecution how to do their job. He doesn't have the right to tell them to present his evidence. They have to present the fact that it exists. They don't have to present all of it. The court made that clear in the ruling. It goes on to say, but the state ignored Baldwin's letter and jammed through its presentation in barely more than 1 day. The state did so by violating nearly every rule in the book. It did not explain the meaning or purpose of Baldwin's alert letter to the grand jury. It did not tell the grand jurors that they had the right and, in fact, the obligation to request and hear all exculpatory evidence. Quote, it is the duty of the grand jury to weigh all the evidence submitted to it, and when it has reason to believe that other lawful, competent, relevant evidence is available that would disprove or reduce a charge or accusation that would make an indictment unjustified, it shall order the evidence produced. Different than the case law that the court cited, isn't it? It goes on to say the state did not make Baldwin's witnesses available to testify. Well, the grand jury didn't ask for them. So there's not much the state had to do if the grand jury didn't ask. The defense goes on to argue when the grand jurors ask questions about exculpatory witnesses or facts, the state instead forced them to hear answers from the state's chosen and usually paid witnesses, even when those witnesses had no personal knowledge or foundation for giving testimony about the subject. They say, and to top it all off, the state read the grand jury an involuntary manslaughter instruction that violated the court's order, unfairly stacked the deck against Baldwin, and contained language that was inconsistent with both the UG and the state's own opposition to Baldwin's request for a different instruction. Prosecutors have engaged in this misconduct and publicly dragged Baldwin through the cesspool created by their improprieties without any regard for the fact that serious criminal charges have been hanging over his head for nearly 2.5 years. Enough is enough. They say this is an abuse of the system and an abuse of an innocent person whose rights have been trampled to the extreme. They did not go on to finish that sentence with rocking the mic like a vandal, but they did say that Baldwin has been dragged through a cesspool created by their own improprieties, which is just definitely creative legal writing. I don't know. I think in law school, my legal writing professor would have told me I was being over the top, which happened on occasion. On occasion, I was not as restrained as my legal writing professor would have liked. However, this motion, I think, was written both for easy public consumption and for the court. And so you get the more attention or headline grabbing language all throughout this motion. Getting to the defense's legal argument, they argue that the indictment must be dismissed because the state unlawfully deprived the grand jury of critical evidence that disproves the charges or makes an indictment unjustified, and because the state conducted the grand jury process in an unlawful manner, including by providing an improper charging instruction regarding a critical element of the offense. So that is the argument, that they did not provide the exculpatory evidence and that they read the inconsistent jury instruction. They go on to say that the indictment must be dismissed because the state withheld exculpatory and favorable evidence. As described above, Baldwin's alert letter describes piles of documents. The fact that they didn't say stacks disappoints me at my core. Describes piles of documents and more than a half a dozen witnesses who had information favorable to his defense. There are witnesses who saw Baldwin's conduct on set and said he handled guns safely. A witness who said that he, not Baldwin, was responsible for checking the firearm and that Baldwin was not at fault. Halls. It says there are documents corroborating Baldwin's statements that he had no control over the production of the movie, other than the right to give limited creative input about co-stars in the script. Guidelines and industry statements that make clear Baldwin had no obligation to check the gun, and there are also documents and testimony showing that the set was safe. This list of favorable evidence goes on and on and on. And it goes on and on and on. They then go on to talk more about the facts of the case, which they reiterate at length. But they do say that Souza was standing behind Hutchins when the gun went off and was struck by the same bullet that killed Hutchins. His statement to law enforcement following the incident supported Baldwin's case. Similarly, Halls is the only witness other than Gutierrez Reed with firsthand knowledge of the condition of the gun before it was given to Baldwin. He was the only other person other than Gutierrez Reed who was required to inspect the gun before it was handed to Baldwin, and he admitted that he failed to properly do so. Morrissey was required to elicit this exculpatory testimony from Halls and Souza. She was also required to provide the grand jury with specific documents identified in Baldwin's alert letter that reflect those and similar exculpatory statements from both witnesses. I think she's required to let the grand jury know that those documents are available. I don't think she has to produce them. But both Halls and Souza testified, so it's going to be an argument, if they get to bad faith, about whether or not those statements were exculpatory or not. Exculpatory meaning limiting Baldwin's culpability or responsibility. Getting to the argument about the jury instruction. The defense says the state provided an inaccurate jury instruction regarding a critical element of the charged offense because they instructed the grand jury that it must decide whether there was probable cause to support the allegation that Baldwin, quote, discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. They say that Morrissey effectively instructed the jury that Baldwin had a duty to check the firearm for live ammunition and to refrain from pointing the gun at anyone, contrary to her prior arguments to the court and without any support from the uniform jury instructions. They argue that this instruction violated the grand jury's court order, which rejected previous attempts by the parties to provide any instructions that were materially different from the uniform jury instructions. However, then they go back to talking about the witnesses. Like they just dump out of the argument about the jury instructions and go back to Dave Hall's testimony and others, I think, to support that Morrissey is putting the responsibility or the duty on Baldwin in that jury instruction. But as you will remember, in the jury instructions during Hannah's trial, during that jury instruction, there is a place where the prosecution has to state what the action they're complaining about is, because the involuntary manslaughter has doing a lawful act recklessly or negligently, or doing an unlawful act. And you have to describe what that act is. And the jury instruction allows for that act to be described. I think this is the prosecution describing the action that is what they are basing prosecuting him under, which is allowed in the jury instruction. I don't know how this will go at trial if their argument is going to be that Baldwin is guilty because he didn't verify that the firearm didn't have live ammunition. The handling of the firearm and pointing it at another person, I think, is a separate consideration than verifying the firearm contained no live ammunition. Because in the prosecution of Hannah Gutierrez, the witnesses, especially the expert armorer, made clear that it's not the actor that's responsible for checking the weapon, which was consistent with what Baldwin had said in the past. Though in Baldwin's police interview, he says he is, he knows the difference between this type of ammo and that type of ammo, and he does tons of movies with weapons. They all said that if the actor does check, which some actors choose to do, that the armorer then has to recheck. And what we know about this set is that everybody was in a rush all the time. And so rechecking the weapons seems like something nobody on set was going to do. Unfortunately, checking the weapons in the first place didn't happen on that day. We now know from Hannah Gutierrez's trial, but it was Hannah Gutierrez and Dave Hall's responsibility to check the weapon. So if they're going to prosecute Baldwin, and if this is the jury instruction that they are going to try to use, I don't think this is going to be successful, because I don't think the prosecution is going to be able to prove beyond a reasonable doubt that verifying that the firearm didn't have live ammo in it was Baldwin's responsibility based on everything that we saw in Hannah Gutierrez's trial. I think there is an argument about pointing the firearm in the direction of another, because all of the weapons experts that testified previously, and I imagine would testify again, is that it is never okay to point a weapon in the direction of another. And that even when we heard from different witnesses about how film sets operate, that if a weapon was going to be pointed directly at a camera, that there were quite a lot of precautions that were taken. And we heard that testimony from multiple witnesses. I think most from Joel Souza, but from others as well, about how the camera operators would be protected, how the camera itself would be protected because of how expensive the lenses and the cameras are, and that there is a substantial amount of setup required if they know that a weapon is going to be pointed at the camera, or that there would be a person right behind the camera when the weapon is pointed in that direction. So I think trying to prove that Baldwin is responsible for checking it is not going to get the prosecution to a conviction. I think there is a stronger argument at trial based on everything we saw in the last trial, that pointing the weapon directly at Helena Hutchins is the action that is negligent use of a firearm, which means Baldwin was negligently using a firearm, and that was the illegal underlying basis for the involuntary manslaughter. He was doing something that was illegal, and that illegal thing led to the death of another, versus arguing that he was doing a legal thing. I think that's a stronger argument for the state. We'll see what they do. Back to this motion. The defense continues to argue that even the testimony shows that the duty shouldn't be on the actor. And they quote testimony between Brian Carpenter and Morrissey at the grand jury saying, quote, Morrissey, and whose responsibility is it to ferret out any possible live rounds on a movie set? Carpenter, it's the armorer's responsibility. They also say in their motion that Carpenter acknowledged that the actor has no obligation to even watch the gun being cleared. He said that at trial too. And he says, yet Morrissey never presented any of that evidence to the grand jury and read an instruction to the grand jury that improperly imposed this non-existent obligation. Morrissey's inaccurate jury instruction is an independent cause for dismissal. The defense then goes on to argue that the state did not advise the grand jury of its own authority. What's interesting is this was at the end of a grand jury's term. And I'm interested to see how the state addresses this, but it would be my understanding that the grand jury would be advised of this during their term, that they can ask for things so that each prosecution can read them the target letter and they know that they can request those things because they're in their general instructions at the beginning of a prosecution or the beginning of a grand jury session, not necessarily in each, because they sit for multiple grand juries against multiple targets. But I'm interested to see how the state lays that out and how that happens in New Mexico. But the defense says very clearly, from case law, a grand jury may order that evidence be produced over and above that initially presented by the state, and they have a duty to weigh all evidence submitted to it. May. So there is this difference between some of the case law saying the grand jury may do this and giving the grand jury discretion, and the statute saying they shall order the evidence produced. But the case law is all very clear that the grand jury can choose to call for evidence or not call for evidence. And then they go through why they believe that Morrissey actively dissuaded the grand jury from asking for more evidence. So all in all, the defense is arguing at length, A, that there was prosecutorial bad faith. And if that hurdle is met, then the court can evaluate whether or not the exculpatory evidence should have been presented in a different way, whether the prosecution simply reading in the target letter and then asking the grand jury if they wanted to take a minute was sufficient. Let's actually look at that language real quick, because I know that we didn't cover it in this episode, even though we covered it on the live stream. And again, we don't have the transcript from this grand jury. I think that's appropriate. So we have to go by what the defense is saying in their motion and take it at its face. They say that she did not explain the meaning or purpose of the alert letter and introduced the letter at the beginning of the proceeding by simply stating, quote, "There is a grand jury alert letter from the target of your consideration," and then read the letter into the record verbatim without explaining its practical significance, why it had been submitted, why it was being read, or what the grand jurors were supposed to do with it. Again, I'll be interested to see what instructions the grand jurors are given before they hear anything, like what their opening instructions are, because the opening instructions probably cover all of this and tell them what they can ask for, not the prosecutor, the instructions from the judge. It goes on to say, nor did Morrissey explain that the witnesses identified in the letter were available to testify and that the grand jury was obligated to request the presentation of the evidence. They say in their motion that Morrissey simply stated, quote, "That concludes the grand jury evidence alert letter from the target. So there are witnesses ready to testify now. However, it depends on what you want to do. Do you want to take a break to consider the alert letter, or do you want to just begin hearing witness testimony?" It seems that then the grand jury took a break, and the defense says in their motion, after a short break, the grand jurors asked about typos in the letter, making it clear that they had no idea what New Mexico law required them to consider. We'll see. Morrissey stated that she, quote, "can't fix the typos on the grand jury evidence letter because it's not ours." They argue that that's conveying the impression that reading the letter was a formality before she commenced the hearing of evidence. Morrissey then asked the grand jury, quote, "Do you have any other questions? Anybody else have any other questions? You want to tell us how you want to proceed." And then the foreman of the grand jury said, quote, "I think if that's the end of questions about the letters and the warrant letters, we'd probably proceed with witnesses if that's okay." So the foreperson said, if that's the end of the letters and warrant letters, let's move on. So the defense wants to argue that she was obligated to present all those witnesses. I don't think that's what the case law says. But they have to get through the hurdle of bad faith first before any of that can be considered. Will the court find bad faith or not? I don't know. We don't have the entire transcript. But then they get to the issue of the jury instruction and whether or not the way that the prosecutor described the obligation or duty of Alec Baldwin was a problem. And I can understand the defense's argument that saying that part of the finding was that he failed to check the weapon implies that there is a duty on his part. We will see how the prosecution responds to it. I think if there's any consideration to overturning this indictment, and that's a very outside possibility, that it would be on the jury instruction and not on anything else. Oftentimes, courts will not allow a prosecutor to refile a case more than once. You file the case the first time and dismiss it. You can refile it one more time. I have not found any specific limitation in New Mexico. It is possible that in New Mexico, as long as the statute of limitations hasn't expired, that the court may allow it to be refiled a second time, or the court may allow the prosecution to show why it should be allowed to be refiled or reindicted a second time. So an initial filing, a first refiling, a second refiling. So is it possible that even if this indictment got dismissed, then it would just get indicted again? Yes, it's possible. But I have not seen anything that specifically limits the prosecution in that way. I will say that the statute of limitations in this case, which was much easier to find, is 5 years from the date of the offense. So there's no concern here that we are going to run out of the statute of limitations, and we will see what the court decides. This is going to be the beginning of waves until we get to the tsunamis of litigation. What I have seen from these parties is that both the prosecution and defense is treating this case a lot like civil litigation. There is going to be a lot of written motion litigation. Other things we learned from these 700 pages of exhibits, and if you would like me to go through more of the tea and less of the legal, let me know. Key takeaways from me. 1, Baldwin was offered a misdemeanor plea deal for 6 months of unsupervised probation to say that he negligently handled a firearm when pointing it at someone and pulling the trigger, which I think the evidence in the last trial has established, and I think the weapons reports have established. He didn't do that and hasn't seemed to ask the court to extend that offer, even though the prosecution withdrew it before the deadline. 2, there are text messages between Sarah Zachary and Seth Kinney where Sarah is complaining that Hannah has called her a "see you next Tuesday" more than once. There are also lots of text messages between Hannah Gutierrez and Seth Kinney about how Hannah is doing her job, whether or not she has been imbibing in either alcohol or narcotics well in the evening on the film set, him advising her to post none of that type of behavior on social media, talking about doing her job as an armorer and what that means. Texts where Seth Kinney, is showing Sarah Zachary that he is reaching out to Thel Reed about Hannah and Hannah's job duties, where Seth is very much saying that he was the one who had gotten Hannah this job on Rust, which we also saw in her trial, and him being very stern with Hannah over her mailing back weapons to him that were still loaded with blanks, and explaining why that was absolutely not okay. He actually called it a party foul in his texts. We also saw the full transcript from Dave Hall's proffer, and we can go through that if you are interested. It would probably take a full live stream to go through that entire proffer offer and see what Dave Hall's had to say. Not substantially different from the parts I've been through to his testimony at trial, just more in depth. And we also now have the full weapons report from the FBI and some of the reports from experts excoriating the Santa Fe Sheriff's Department for how they did this investigation, for how long it took to search the prop truck. Again, talking about the fact that Hannah was able to get into the prop truck between the shooting and the search warrant and take things out of the prop truck. So lots of questions that I'm sure we're going to see come up if and when this goes to trial again. So with all of that, we are going to be flooded with waves of litigation before this goes to trial. Because after this ruling happens, well, they might ask to do an interlocutory appeal before this goes to trial. They might not. But then we're going to start getting into motions in limine. What can come in and what can't. Things that Baldwin's attorneys have learned from Hannah's trial. Things that witnesses have said. They've already pointed out in this motion that they thought that Brian Carpenter said things at the grand jury that were different than what he said at trial. So we're going to see all of those motions in limine, I think, be fiercely litigated before the trial in July. And honestly, sitting here at the very, very end of March, that's not a lot of time. So I imagine that the Rust case is going to keep us quite busy. Let me know down below if you have any questions. And Law Nerds, raise a Matt Black Law Nerd Tumblr and say it with me, as my voice has gotten so dry by the end of this episode. May your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. May the odds be ever in your favor. I will see you in the next one, which will be next month. And I can't believe it. How are we going into the month of April? And if you're going to ask, Emily, can you give us a forecast of what's going to happen next week? No, a ton of stuff has happened between like last Thursday and recording this today on Monday, March 26th. So no idea what next week's podcast is going to hold. I don't know. Will P. Diddy be indicted before then? If so, maybe we'll cover that. But we're going to have to see what happens, and I'll see you in the next one. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at The Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, The Emily Show drops on Wednesdays. Thanks for being a Law Nerd.